criminal jurisdiction.
Read criminal jurisdiction. পালং শাক কেনার মতো অর্ডার পাওয়া যায় এখানে। Go and file a criminal division here. No persistent shall be taken. After 15 days, matter will come after 2 weeks, 3 weeks. Then on the 3 weeks you will go. Why? Opposing. This is also happening. And I am not worried. I will speak on the one day in the floor of the parliament what the Calcutta High Court, one or two judges. To the nation. Nation must know. Is enough. Anyway, my lord, your lordship will decide your matter on merit. It's not that. Not take it another way. Is one of the things that I have got your lordship. I have opened up, which can be argued for before the Sometimes I was thinking that whether I was in a high court or not. But sometimes we forget that we are in a high court. 3 or 4 the ingredients are there. I will come later on. Oh, first of all, whether the FIR discloses an offense. And FIR is not an encyclopedia, my lord. A sketchy fact is enough. Hardly mini trial cannot be held while questioning the FIR. Not a single evidence can be considered without in a case of the crossing before the high. Number 4, the most importantly, malice. I find nowadays that it's a really luxury of the litigant, rather I say. In every case, the malice without having any foundational fact, without having any making it a party. If one word of malafide is enough or not. Even then, if any malafide is there, whether the FIR will be qualified. These are the few questions. Nothing more than that. First of all, kindly come to Miller FIR. Please copy. Kindly take from the case diary. Forwarding note. In producing here with the arrested accused persons, namely Ashish Kumar Shaw, late Professor 47 is transfer, do hereby file this complaint against the above noted accused persons and accused Chandan Kumar Shaw and Om Prakash Modular Enterprise Anand Pandey and 45 others to the effect that today, 21st December at approximately 16.20 hours, during the investigation of Bhatpara Police Station case number 69 transfer under section 61 of the transfer, along with the supervisory officer Inspector Devashish Sarkar and Inspector Abid Hasan, the Morium Walam at DPT, including Bhatpara Police Station at the post and force with LC 2480 Jasmina Vishwas arrived at the PPO at Madhuri Enterprise to investigate the case. We went to the security office of the building, situated at the garage of the multi-story building in the ground floor, and started interacting with the security, namely Modhusudan Doctor and Francis. One certain individual identified themselves as flat owners, including one individual claiming to be the secretary of the flat owners of the committee, namely Chandan Kumar Shaw and Francis. Yes, the investigation and the behavior uncooperatively despite being informed that the case was registered by the chairman of the Bhatpara municipality and was under legal investigation, and that the Honorable High Court in CRR number transfer and kindly allowed the continued investigation of the case. They did not allow the investigation team to continue the investigation. They even warned that the investigation team will not be allowed to visit the PO. They were made to start a notice to them under section 179 BNSS. The investigator became violent, used filthy and abusive language, and constituted the police officers for performing their lawful investigation. Several persons, including outside and women, assembled at the gate area. Despite repeated attempts to explain the legal necessity of the investigation, their behavior escalated into a riotous situation. The matter was reported to the Oshi Bhatpara police station for assistance. He arrived at the spot with the accompanying officer. An additional force that's 18.50 hours. However, even after repeated reports by the Oshi to specify the situation, the individuals, including several women, continued their riotous behavior, used abused language, attacked the police, and started physically assaulting police personnel. Some of the accused person injured some police person while beating and also drank the Oshi by his uniform. This resulted in an injuries to several officers and force, including the investigating officer SI Adirul Hassan, Inspector Abid Hasan did as well as the station for Oshi Bhatpara, Subrata Mandal for the police station, the constable Amit Samad of other accompanying personnel. Finding no other alternative and in order to restore Oshiba arrested the above noted accused person, namely Francis, for obstructing police in the discharge of lawful duty. in the lawful duties, assaulting public servants, and disrupting the investigation process while other accused persons, including accused Ramnan Kumar Rao, Priyank Korea, and Anand Pandey, and K. Well, whether this discloses an offence, this discloses an offence. Which section will apply, which section will not apply. This is not the stage to argue at the framing of the charge. Whether this section will apply, no, this section, not this section. Whether High Court will go into these niceties. Then nobody is required to go to the criminal court as usual at every time it will come. Framing of the charges, etc. It should be scratched from the statute itself. But people will come here and say, no, my lord, decide it. This is the chapter. This section is not applying. This section is applying. Whether by using certain expression or by saying so, whether this writ court can be turned into a trial court. To enter into the question whether this section applies or this section doesn't apply. Whether cognizable case has been made out or non-cognizable case has been. Whether bailable offence has been made out or non-bailable offence. Is it the task of the writ court what my learned friend has invited to your lordships to go into the process? Our case, we have never thought about to come up in the writ court for quashing on FIR. Except in very, very few cases. And with great respect to your lordships, my lord, kindly do not take me amiss if I say so. This High Court has indulged for several years to entertain these types of writ petition. That is the reason, my lord, this is the cases are piling up here. With great respect. Come here, go take an order. No court system, finished. I'm not talking about this court. I'm talking about persistently for 5 or 6 years is going on in this cycle. Indulgence of this High Court is too much to that extent that each and every case one will come and take an order and go. Why this Court Number 28? I have been heard that the Justice Oka has said that there should be a single bench. Why? Better you give this to the 226 court is there. Nothing is required. No application of mine on the very first day. First order is no court system should be taken. Is it appropriate for the writ court to pass an order mechanically in this way? In number of petition number. I am not saying, my lord, kindly do not take me amiss. Today, let me express myself to your lordships, my lord. What a pain being a senior lawyer I am having here in Calcutta High Court. I was also a junior. I have started my practice. To a certain extent, I know about the constitutional law. I was there to come. Senior used to say, "Ja, laki diye petabe." Now, each and every matter, each and every matter. Now, see, Malak, this is the FIR, this is a disposal offense. What more you will not see? Very simple. Very simple. And once an interim order is, my lord is hearing, I am lucky that I am being heard by your lords. I am lucky. Being a state, I am lucky. Painful incident is this. If a political person moves here in High Court, gets an order, you go to Supreme Court, up to Supreme Court will, no, my lord, we will hear the matter within certain days. Despite the order has been passed, High Court could not pass it, hear the matter. Hearing was concluded by me in December 2023. Today, up till the judgment has not been delivered. Where I am living. One of the demands of mine in this Calcutta High Court is this. Only the powerful persons, the political persons, whenever it comes and gets an order. This order is not available to a general litigant.
Mr. Bandhavadh, this is not correct. I believe I do disagree with you, sir.
That's it. Last 5 or 6 years, I am looking into this.
Maybe in few cases, there were cases. You also understand, Mr. Bandhavadh, all cases at this stage being a senior counsel, you know, there are cases where there are multiplicities. I don't say that in all cases. There are cases, obviously.
No, that's all right. My lord, what is troubling us? There is multiplying cases, of course. With a simple these types of FIR and etc. I am not talking about a single one. If you give me scope, I will give you 50 references. The point remains, my lord. Kindly excuse me for saying, it is the duty of the High Court is first to see whether FIR discloses an offence or not. Do not kindly, well, the High Court should not pass a mechanical order, no cognizable, no coercive steps should be taken, or no investigation should be there mechanically. Then one has to come to such a finding. No, there is no offense. It is not disclosed any offense. Therefore, I am passing an interim order. I don't find any single cases. My lord, I am sorry that your lordship is not agreeing with you. Maybe. But unfortunately, I am also not agreeing with all of your lordship's view. We are also in a receiving end. Sometimes patience, sometimes time comes when patience is broken. Time comes. And that time possibly has come today. What I am saying, nothing meaning for particular court or particular lordship. What I'm saying about this institution itself. What is happening? One after another matter, one after another matter. And if I go to a judge and say that you have passed this order ex parte, you have said that this is after 10 days matter will be hard 15 days. Judge becomes annoyed. You are dictating me to hear the matter. Where I have gone? Is it my institution? Anyway, my lord, do not mind.
No, sir.
I am just simple. I don't know whether the moment you have elevated as a judge, you are within a very
Short campus, sir.
short campus.
I don't disagree with that.
Therefore, so many things are not known. So many things are going on, especially in the criminal jurisdiction in Calcutta High Court. Very unfortunate, very unfortunate. Judge becomes annoyed. Why are you saying to oppose? Why you are opposing? I am taking up the matter. I will hear the matter. Interim order is extended. I will hear the matter in the month of March. March will come. Extended order extended. Hear the matter in the month of June. I can't oppose. Judge will come, judge will go. 5 years, 8 years, 10 years. Institution will remain, lawyer will remain for 50 years. Unpolluted institution can be made a polluted institution by a single judgment. Now, this is the FIR has been drawn under
Criminal jurisdiction was all right, sir. You have grievance regarding the criminal jurisdiction or the criminal jurisdiction?
Read criminal jurisdiction. Palong Shah kenar moto order pawa jay ekhane. Go and file a criminal division here. No course steps shall be taken. After 15 days, matter will come after 2 weeks, 3 weeks. Then on the 3 weeks, we will go. Why? Why you are opposing? This is also happening. And I am not worried. I will speak on the one day in the floor of the parliament what the Calcutta High Court, one or two judges. I have to say it to the nation. Nation must know. Anyway, my lord, your lordship will decide your matter on merit. It's not that. Not take it another way. Is one of the things that I have got your lordship. I have opened up. Do not take anything personally.
No, I have never.
But I am more thoughtful than any other poor person. Whenever I go, either in the floor of parliament or whether in the Supreme Court, if I speak something for this, this is your High Court. I have to hear that. If I simply I have in a practicing lawyer coming to court, from house to court and court to house, and with in a Friday in a good party, then I would not have bothered you. Remember, this is the sections has been given 126 so and so, so and so. Now, kindly see what notice they wanted to give it. The notice under section 190 or 160, 169. Part because of another case was initiated earlier. 179 BNF. What is the order about that? Kindly come to 12 February 2024 order 140.
But would you want to do it before the other bench?
No. Before you are not before you. No. It is not. Nothing has to be said to you against you. You never mind it. Rather,
No, another bench has passed an order.
no. I want to do it before you. I with the another bench, it matter will not be never be. That's the reason I said I am lucky that the matter has come to you. That this matter will be finished. But I am tired of. Why I am saying I am tired of. Last 4 or 5 years, every day, went on, argued a matter for 15 days to 20 days, hearing the petitioner for 60 days. This council judgment has not been delivered. You dismiss you allow his petition. Do not mind. I do not mind. But please do something. I am tired. I have said to the court also, I am tired of. No, when he used to come in 1981, came to the court, begin was there. It's two big institutions where I was working. Every day learning, every day energy, every day. From the judges got the spirit, from the seniors got the spirit. Even 4 or 5 years before, when I used to come to the High Court, there are so many things to learn. Today I feel that this institution has been failed to discharge the duties. This I'm not particularly saying it, but I think frustration of almost 90% lawyers are there. Ki hobe dada? Piling of matters, clients are coming. Fortunately, I have got this senior gown in 2003. Otherwise, I did not have direct contact with it. Otherwise, I would have been admitted into a mental hospital. So many persons, bench, the lawyers, juniors, etc., judges, says why judges are annoyed when they are mentioning. Have anyone has felt the pain of the lawyers? 5 years, 6 years, 8 years. What is the writ petition about? Criminal division. What is going on? This is nothing to you, but I am saying when I was getting a chance to tell. Will not kindly see the order.
Order.
And this page 140. This is an order passed in earlier petition. That is their criminal division, this petition. But I am so disturbed. I couldn't sleep for 2 nights when a judge has said to me, you are dictating. When I'm saying, kindly hear me. I'm so shocked. Interim order was ex parte. The day I went there, this is the lawyers on the other side. Please hear me. You have passed an ex parte. Hear me. No. When I was insisting, hear me. You are dictating me. You are having a bad behavior. I have to hear this. After putting 44 years practice from a criminal bench. I will not forget that day the judge has said this. I will not forget. And I will make her understand what you have said. Can you read page 114? The petitioner seeks quashing of FIR in connection with Bhatpara police station case number so and so. But last part, the learned counsel submits that the petitioner entered into a development agreement with Arjun Singh, then chairman of the Bhatpara municipality on 8 Jan for construction of a residential and commercial complex under the PPM model. The project was completed and complete certificate issued and certificate of the state was in the present. The petitioner has directed to serve copy of the application along with annexure thereto upon the opposite partner. Let the matter appears under the heading contested application. Investigation of this case shall continue. No coercive steps can be taken against the petitioner in connection with the present petition till 28 February or until further, whichever is the earliest, subject to suits. Now, in here, investigation has directed to continue. No coercive steps shall be taken. So, for the purpose of conducting investigation, I have to start the notice, and that was the purpose in not the FIR. The notice which I wanted to serve for conducting the investigation. Kindly come.
Just one thing you satisfy me.
Yes.
In your opposition, you have taken the point that there was a change of the investigating
Yes.
officer. Where is that in the case diary, sir?
Page number one.
That was on which date? Don't have to give me. I want the date actually.
2nd December 2020.
2nd December. And 2nd December 2000. And this person went
21st December 2020.
for serving the notice.
Right? This is the past.
Yes, Mr. Bond.
What I have taken in my affidavit in opposition, Lordship has read it, I think so.
I will glance through
Yes,
it.
therefore your Lordship asked me the question. If it is required, I will again point out, but the point I have to answer, I was ready with it. I have said I have nothing to do, more arguments I am not required to do. He has made so many arguments, so many facts, so many things, so many things. I am not going and falling into trap.
I think you don't argue anymore. I don't think you have anything to argue. Right?
Case laws,
Ah,
I can give a minute. I just say the case laws, not just one is this first of all. Joseph down, but encyclopedia, your Lordship will get it or I can hand it over. FIR is not encyclopedia. When the investigation by the police is in progress, the court should not go into the merits of the allegation in the FIR. Police must be permitted to complete the investigation. It would be premature to pronounce the constitution based on hazy facts that the complaint FIR does not deserve to be investigated. That's Milad Niharika. Niharika's judgment 2020. Malad, can I, if your lordships do not mind,
yes.
do not mind, can I just hand up my note?
Yes, 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 yes. Only one point I will ask you to argue. This is I wouldn't have, but since you have enclosed and opened up everything in the affidavit in opposition, uh, one point I believe should be a part since I've got to deliver a judgment on the issue that evidentiary value of an injured witness.
No, this is not the stage at all. They have done it. This is not this. I think this is not the
This
stage.
is not the stage, but
Not,
these documents have been unnecessarily enclosed in the
this is
affidavit.
not the stage they have done it. By mistake, it has been done. This has not been done. Very junior has done it. This evidently. I said I submitted to test the FIR.
That was enough, actually.
That's enough. For that, no evidence is required. Whether it discloses offense and offense only. And so, what the malafide, I have to say.
Yes, malafide.
Yes, kindly just hear this. Two principles. Because it is often it comes in two principles, two judgment I will show to your lords. One of the judgments of justice delivered by Justice Manoj Mukherjee in Supreme Court. That I will show fast. কোথায় গেল তো জুনিয়রটা কোথায় গেল দাদু জাজমেন্টটা পড়েছে না না পড়ে মেলাপিটে করে বলছে Madam, kindly come to internal page 162. In one of the conference, I will not tell the name, one junior came long years back holding the conference. And you see there is a one judgment is there. That time it is not there. That is the judgment is there. Well, I know what judgment you are referring. You know, well, yes, this judgment is bogus. Bogus. Read it. Find it out. Report in Calcutta High Court notes. Incidentally, it was his father's judgment. I'm going to read the judgment with me. No, nothing is. I'm going to read it with me. Read this 5 lines. Then I said he was not that foolish like you. Now he has gone very high level. And always I say, don't worry, your son will come and hold a conference with me and say this judgment is wrong. And again, I have to convince you are foolish. He was right. I will just show to your lordship in the state of Maharashtra versus Ishar Piraji Kalpatri, 1996, 1 SSC 542. Often now, malafide is paragraph 22 to 24. Internal page 170. And you look into these two judgment, I will show. In fact, lordship got in that. In fact, the question of malafide in a case like the present is not at all relevant. If the complaint which is made is correct and offense has been committed, which will have to be established in a court of law, it is of no consequences. The complaint was a person who was inimical or that he was guilty of malafide. If the ingredients which establishes the commission of the offense or misconduct exists, then the prosecution cannot fail merely because there was an animus of the complaint or the prosecution against the allegations of malafide may be relevant while judging the correctness of the allegations or while examining the evidence. But the mere fact the complaint is guilty of malafide would not be ground of quashing the proceeding. I don't need to read furthermore. Another judgment, just your lordship kindly. I don't know whether your lordship have ever considered. That is not 2023. 23. You can forget it. It is. You don't go judgment. Yes. Now, 2023 SCC online. It is what was the
112.
Yes. Kindly come to paragraph. Paragraph 70. For reasons more than one, we can incline. My lord has got
70.
70.
Yes.
For reasons more than one, we are inclined to the view that the writ petition before the High Court do not have a succeeded event. Even the plea of malafide were advanced and accepted as a ground of assent for the FIR based on what has been laid down in Bhajan Lal's. We have perused the writ petition filed by S. Answers have not hesitant to agree with Mr. Hegre that the pleadings are insufficient to return a finding that the FIR is an outcome of a malafide. No doubt, certain allegations are leveled against the government and its chief minister. However, such allegations are vague and general in nature. Malafide motives are required to be affirmatively pleaded and proved. More, however, no foundation in that behalf has been laid, and naturally so the High Court even did not examine whether exception could have been taken to the FIR on the ground of malafide. Secondly, neither the head of the political executive did so and so. Incumbent, not that the administrative officer was personally arrayed as a party to any of the proceedings. Now, law is well said that the person against whom malafide or bias is imputed should be pleaded. As the party responded to the proceeding as nominee, and that is in his absence, no inquiry into this so and so be having regard that this is the incumbent holding the office of chief minister of the state. Regard to this is the incumbent holding the office of chief minister of the state against whom malafide is alleged is not on record. We are loath to attach any importance to the allegations of malafide even. Thirdly, it must be remembered that when an information is lodged at the police station, an offence is registered in respect of a disproportionate materials collected during the inquest and evidence court. That is decisive for determining the fate of the accused. To our mind, whether the first information report is an outcome of the malafide would be of secondary importance. In such a case, should be the allegation of malafide be some prima facie work would plea into the insignificance or insufficient materials are gathered for semi-insurance. These are the malafide. There were two judgments, and two are from the our High Court. One judge, Supreme Court judge from the other. They have not been paid allegation against to Reba something. They have not been made party, etc. I don't need to. आपकी जज साहब की judgment में दी रहा हूँ ना. Can I just hand over, my lord?
Yes, please.
No. It, not is do not treat it as a written notes. I am just giving this my synopsis. These only 2 pages are there. Do not look into any other cases. Please do not mind.
No. I have no issues. I worked with you, assisted you in many matters. I worked with you, assisted you in many matters.
Just I made a synopsis and their cases have been distinguished in the other pages. Mulad, I don't need to argue more. You're deeply obliged. Kindly do not take anything personally.
No, I don't take things personally,
This
sir.
is the view of mine. I may be wrong. I'll be happy if I am wrong. But I am in a very
And I also believe that those were not directed against me also.
no, nothing. Since it was nothing against you, that's the reason I was very clear. Nothing. You are very nice. And you remain in constitution bench, please. This is good. Develop the constitutional law. This is very nice.
So am
And
I?
a judge being a judge. See, I can tell you one thing, my lord. All of our duty is to advance the constitutional right of the citizen, not to negative the right. Why constitution is dynamic? Why? Because of this. Every part of the organ, every organ of this country, one goal, advancement of the constitutional right, and two, reach to the poorest and the poorest people. Deeply of the scholars.
When written